Hello, Justice Maha. This is Reem. I would like to begin by reading out a short statement, which in return I will ask you and the parties to confirm is correct. I hope that is okay.
Yes.
This hearing is in the matter CFI-112-2020 before Her Excellency Justice Maha Al-Mheiri and is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the Registry in Dubai on the judge's instructions. The claimant is represented by Azhari Legal Consultancy. Lead counsel is Dr. Rassan Robert Azhari. The defendant is represented by Bin-Eid Advocates and Legal Consultants. Lead counsel is Abdul Karim Ahmed Abdullah Eid.
Okay, thank you. Mr. Rassan, you may proceed.
Yeah, Your Excellency, good morning. May it please the court. My name is Hassan Azari. Today, we discussing the case 112-2020. A short summary of the facts is that the claimant and the defendant entered into a lease agreement to a lease tank located in Mheiri Free Zone in Sharjah. And Her Excellency, may I ask you, do you have access to the case bundle?
Yes.
Then I would kindly address your attention to the storage lease agreement. It's page 5, 6, 7, and the following of the case bundle. If we go to the lease contract agreement, it clearly provides a commencement date or a term from August 2020 to 27th November of 2020. This is on page 8 of the case bundle. Further, the lease agreement provides, and I think this is one of the issues in this case, under Article 7.2, which is on page 10 of the case bundle, that the defendant shall not be responsible in any manner whatsoever for any damage, indemnity, and loss. Further, the parties agreed in Article 26, which is my online case bundle is. But anyway, in Article 26 of the lease agreement, they said this agreement is subject to and shall be governed by the international laws, and the parties shall submit the exclusive jurisdiction to the courts of EIFC. In our opinion of the claimant, Article 26 also constitutes an issue because, in our opinion, there are no international law as such. Consequently, the DIFC laws apply. Then further, just on the 3rd September 2020, at or around 16:20 UTC, the claimant scheduled oil for delivery by ship, provided by a shipping company called P Trans Oil to the tank in question, and after that the claimant got aware or informed by the defendant that the tank is not available. As a result, the claimant suffered losses or damage of 239,367, and further losses in profit of at least 350,000. In this context, I refer to the particulars of claim. page 66 of the case. Here we clearly mentioned that the claimant had to pay a demurrage of 239,000 by submitting supporting documents, and that he has a loss in profit. After the
Dr. Rassan, I am aware of the history of the claim.
okay.
Today's case management conference is to discuss more dates and if the parties have issues before commencing with the documents provided to the court.
Okay, then let me. Okay, I think the issues of the case. I mean, we've submitted our list of issues. Then there was another issue that this is the counterclaim. The claimant raised a counterclaim of 300,000 as a consideration for the damages incurred by our client as a result of a termination. In this context, we apply to strike out the counterclaim because the claimant, or sorry, the defendant failed to plead the counterclaim properly. He didn't plead a cause of action. He didn't plead a legal conclusion, and also he didn't plead in reliance to statutory provisions. The defendant simply asserts that he had he suffered damages of 300,000 dirhams, and this, even if you go to page 137 of the case bundle, it's just really without any justification. One second. In the defense, in the latest amended defense and counterclaim, on page 137, the claimant just asserts that he suffered loss of 300. If you go to page 137, 7.5, number B, and this counterclaim of 300,000 is, in our opinion, it has to be stricken off. Yeah.
If you're requesting that the counterclaim be struck off,
Yeah.
is that true? That's a question. Are you requesting for the from the court to?
Yes.
Okay. Okay. This is not the right procedure for you to do that. Today's case management conference is only to discuss dates. I don't have any live applications in the case case file. So any applications that you want to file, that would be in a separate matter and not to be discussed in today's hearing.
Okay, then let's discuss the list of issues. I think the list of issues, I briefly touched the lease agreement. Our list of issues is whether the DIFC law shall apply, and whether the provision 7.02, which I referred to earlier, is valid or not according to Article 73, paragraph 2 of the implied terms in contracts and terms law, and whether or not the unavailability of the tank in question caused the damage of demurrage and or loss of profit by the claimant. And eventually whether or not the defendant's counterclaim is certified. This is our list of issues, which we could not 100% agree with.
Okay. And then there's the defendant's list of issues.
लिया हमारा पेंसिल तुम लिया
Dr. Rassan, other than that, the dates are agreed? There are no other issues?
The dates are agreed, yeah. The dates are agreed.
Okay, it's only the matter of the list of issues where the parties do not agree on a a list, on an agreed list. Is that correct?
This is correct, yes.
Okay. One second.
And I think the defendant didn't mention in the list of issue whether the DIFC law shall apply, and I think this is an underlying question for the case, as well as whether the clause I quoted before, 7.02, it should be deemed null and void as it violates Article 37, paragraph 2 of the implied terms contract. Without these two issues, we cannot continue with the case because it really depends, your decision will depend on which law you should have to apply and whether the provision 7.02 is valid or not.
I'm sorry, can you repeat that?
I said the first issue, which law is applicable, I think this is an underlying principle now in this case, because without the applicable law, we cannot come to a decision, because we don't even know which law has to be applied. But we pleaded in our particulars of claim, and it applies that the DIFC law shall apply. And the second issue, we couldn't agree with the defendant is whether the consequence of the applicable law, whether the clause 7.2 of the lease agreement, which excludes any liability of the defendant, is in violation of Article 37, paragraph 2 of the implied terms in contracts and unfair terms law. So these are the two issues we couldn't agree
Okay, thank you. Mr. Abdul Karim?
Yes, I am with you, Advocate Abdul Karim bin Eid, a defendant lawyer presenting about the defense list of the issue. Also, you told him. We are also mentioned page number 2.
Of the order.
Whether or not the delays resulted due to the non-performance of obligation as per contract by the defendant. And also, second one, whether we are not the whether or not procedural delays were discussed between both the parties before signing the agreement. Also, whether or not the defendant availed the bona fide right. Bona fide right. Yeah, bona fide right. Lesser right to avail the privilege of the benefits by the clause number 7, subclause 2 of the agreement. Fourth one, whether or not the rent claimant in counterclaims of the tank is viable to lessor till the date of the tank has been used by the lessee. It's for issues for all we have between us and between doctor. Other things all we are agree, both parties. With this CMC meaning we are what we agree, we are going to the trial. So we are agree all things and accept these 4 things. Your Excellency. Thank you. Hello?
Yes. Dr. Rassan,
Yeah.
you want to say something?
Well,
I'm sorry?
Well, I could. It was very difficult to understand Mr. Abdul Karim, but I think
This also is written also. Written
I
also,
think
we submit the paper, yeah.
I think he's addressing the issue whether it has been disclosed via the conclusion of the contract that the tank was already rented out to a third person. But I think this is a matter we need to discuss in trial, which will be subject to witness statements.
Video.
I mean, Your Excellency, what the defendant is basically pleading is that the defendant informed the claimant that the tanks have been already rented out to a third party at the time they signed the contract. But I think this is not an issue to be discussed in the case management conference.
Okay, the court is going to look at the list of issues and is
Yeah.
going to revert back to the parties with an email with direction in relation to what's the next step.
Okay, thank you very much.
But in relation to the dates, it's agreed, right?
Yes, agreed.
Yeah, it is agreed.
Okay, thank you both for your time. Thank you.
Thank you.
Thank you very much.
Thank you.
Thank you.
Very nice, sir. आपको बहुत अच्छा बोला.
Supreme Court lawyer, your first time.
Very nice.
Thank
अच्छा
you.
बोला सर, फर्स्ट टाइम के हिसाब से. बस हम अगली बार क्या करेंगे, आपको थोड़ा लिख के, जैसे आप मुझे पता
इनको ये नहीं समझते जो है ना
वेदर
इसके
और
अरब
नॉट, ये थोड़ा पढ़ना सीख लो.
हाँ
ये मैं आपके साथ पढ़ाई